I asked for attorney's fees on both of them as a result of frivolous pleadings filed by the defendant here.
This matter is before the court on the defendant's objection to the referee recommended order. Ms. Wilson, you can proceed.
My objection obviously has to do with the fact that the evidence that I submitted to the court was not properly scanned in. He had referee Croto had no paperwork that I had given to the clerk's office in any logical order. I have no idea what did actually end up on his desk and what ended up not being on his desk to be able to correct the situation. Nor am I versed in Zoom to be able to screen share. I told him, I was like, okay, next time we get together for a hearing date, I will obviously have perfected those skills in order to make sure that he has the proper documentation and I'm able to present that to both the plaintiff and him during proceedings.
Ma'am, you understand that in the notices and the whole thing on the Zoom, it tells you that you're responsible for those documents and you're responsible for making sure that you are able to screen share those and present those to the court.
No, that wasn't ever on my screen. That warning was never on my screen.
Okay, well, it's your responsibility as a party. It's no different than Mr. Vollmerine. If he wanted to present something and he couldn't do it at the hearing, it's nobody's responsibility but his. So in your case, it's your responsibility to make sure that those are able to be shared and presented to the court.
Okay. Yeah, that was not on the screen that I saw at all. And in addition to that, like this documentation was not properly scanned in by the clerk's office anyway. So he had no way of even knowing what I was presenting. Either way.
Again, it's your responsibility.
Okay, so when I hand in the paperwork to the court for evidence, for submission of evidence, and he does not receive that documentation after it's out of my hands, there's nothing I can do about that particular line of evidence submission.
You can do. You can, as you already acknowledged, you can do the screen share. You can present it. I don't know if this hearing was in person or not. I assume it wasn't.
It was via Zoom. Sorry.
Okay. So, but it's it's your responsibility to make sure that those get submitted at the time of the hearing. Because what will happen when you submit documents to the clerk's office, it's not unusual. The parties submit voluminous documents, and yet they may use a fraction of those documents at the hearing. Just they determine that they're not useful or that they don't want to admit them, etc. And so it's your responsibility to make sure that that gets done properly. So go ahead.
Also, there was the referee in-camera interview. Do we have access to that interview?
An in-camera interview is privileged and confidential. We do not have, it is not shared by anyone. It's not to leave that particular room. So the parties, the attorneys, even myself will never find out what occurred at that. And
the next issue was the fact that referee Croto had stated in previous proceedings that he disliked breaking up testimonies from witnesses. So I did not subpoena two of the witnesses that I was going to have to recall due to that fact that he had stated that displeasure in that. In the last day, it was forced closing. The closing statements was demanded, even though the paperwork was not correct. I told him that I would learn how to submit the paperwork via Zoom screen and everything, but there was no chance at all for me to counter an expert witness. I have no idea what he admitted to, not ever calling me back, never contacting me. And there was no opportunity for me to rebut his testimony as an expert witness.
Didn't you call a CPS worker and had that person testify?
I had the one person, yes.
Okay, so you know how to get somebody to testify then, correct?
Yeah, and I was not afforded the opportunity to get the evidence I needed for an expert against an expert witness. He
There was a-
testified.
There was a hearing on May 12th and then
Mhm.
again on August 3rd. You could have subpoenaed an expert for either of those particular hearings.
And I would have if I knew what the plaintiff's expert witness was going to testify about.
You can't just say, well, geez, they've presented their witnesses and now I think I need an expert. That's not how trials work, ma'am. You have to have your witnesses present and available for testimony.
And I understand that. However, the simple fact is the expert witness that the plaintiff called would not contact me back. And I have no idea what he's going to witness against. So therefore I have no recourse as to
Okay.
this is the expert witness that I would call
Okay.
to counter his testimony.
The other party's experts are not required to contact you back. They're not required to have any communication with you. They're the other party's witnesses. They're the other party's expert, and they testify at trial. And you have to prepare your case, just as Mr. Vollmerine had to prepare his case, and present the case as best you can. You can't, if you wanted to have, let's say, information, or you wanted to have forewarning as to what the expert was going to testify, you could have had that expert take a deposition, and you could have went through all of that testimony at that time in preparation for your hearing.
With the witness who does not get back to anyone, including the CPS witness.
You subpoena the person and they are required to show up for their deposition. Or if you subpoena them, they're required to show up for the hearing. So obviously you have a disadvantage a little bit because you're representing yourself, but that's the responsibility that you take on when you represent yourself and don't have an attorney. So that's unfortunate. Anything else?
Yeah. The wording that the referee put for the attorney fee section, last page, third paragraph, it implies that I'm to pay all attorney fees in the show cause hearing, which is what the entire custody case is the show cause. He didn't specify it was the show cause for contempt of court or if it was the show cause for the entire situation.
Okay. Mr. Vollmerine, what's your response?
She did not put that in her objection, Your Honor.
Okay. Anything else, Mr. Vollmerine?
I guess I'll just add to that. There were two competing show causes. I asked for attorney's fees on both of them as a result of frivolous pleadings filed by the defendant here. So my interpretation was that it applied to both of those.
Okay. Anything else?
No, Your Honor.
Okay.
Well, is this in response to all of what she was
Yes.
saying? Or that
In response to everything.
Okay. I guess as far as the other items go, I think the court pretty well hit on it. And I also will primarily rely on my pleadings there, but it was the defendant's responsibility to subpoena her witnesses and to prepare her documents and exhibits for trial. She has shown an ability to do so in the past and just chose to not do so this time. And so I'd just like to reiterate, I'd like attorney's fees for having to appear for this motion as well.
Okay, thank you. Anything else, Ms. Wilson?
Apparently not.
Okay. Well, in this case, the court did have opportunity to review the ruling of the referee. He did make a very thorough factual and legal decision in this particular matter. He did address and found issues of credibility to be substantial in this matter, as well as finding that the established custodial environment was with the plaintiff in this case. And as a result, the court, after I reviewed that and thoroughly reviewed it, the court cannot determine that the referee made either a factual or legal error in this matter. So the court is going to deny the objection in this matter. And that will conclude the case. And
I do have something that's slightly off topic that has to do with paperwork and filing in your guys' office, if you wanted to hear about it.
well, if it doesn't go to the objection, I don't care to hear about it because it's not before the court today.
So the fact I have somebody else's information from their court date and their rulings and their custody case in my envelope sent to my home isn't concerning.
Well, that obviously it's always of a concern, but it doesn't affect these particular proceedings. And what you need to do is you'll need to file a complaint with the front of the court because they were been the ones that sent that out to you. So you can file a complaint with them.
Okay.
Court will end this matter at 10:46 a.m. You're free to go. Have a good day.
Your Honor, real quick, my attorney sees was that denied.
I'm denying that at this point. Yeah.
Thank you.